Okay, so hi everyone. Tonight we will discuss civil remedies for the collection of duties and taxes under the CMTA. So these are provisions from our CMTA which tackles how the Bureau of Customs collects duties and taxes. These are just a few provisions from our CMTA, so expect just a short, brief discussion tonight on this topic. Okay. First and foremost, we should remember that the primary function of the Bureau of Customs, as reflected in Section 202 of the CMTA, is to assess and collect customs revenues from different sources. And what are these different sources? From duties, from imported goods, other dues, fees, charges, fines, and penalties under the CMTA. So again, remember that this stems from the notion that it is the primary function of the Bureau of Customs to assess and collect customs revenues in the form of duties and taxes and other charges, okay? Even fines and penalties under the CMTA. Remember that ideally, the Bureau of Customs or the goods that you import through the Bureau of Customs is not released unless and until you pay the necessary duties, taxes, and other charges. Remember, as stated in Section 431 of the CMTA, goods declared shall be released when duties and taxes and other lawful charges have been paid or secured. Okay? So remember that payment of the lawful duties, taxes, and other charges is a prerequisite before the goods that you have imported are released from customs custody. So, sa madaling sabi, hindi mo mare-release yung kargamento mo o yung inimport mo, yung importation mo unless and until nagbayad ka ng duties, taxes, and other charges that are due upon your importation. Take note also that under the next few provisions of the CMTA, sections 435 and 436, which are flashed on your screen, no, your goods or your imported items will also not be released, or the release shall be withheld unless and until you pay the necessary charges, and under section 436 the necessary fines and surcharges. Again, as you can see from section 435, the release is withheld unless and until you have satisfied the payment for freight, lighterage, or general average or other charges upon the goods. And under Section 436, if your items or if your importation has become liable or subject to fine or surcharge, you should pay those fines and surcharges first before your goods can be released from customs custody. So again, as with duties, taxes, and other charges, lahat yan dapat bayaran mo muna before you can secure the release of your goods from the Bureau of Customs. Okay? And what is the effect? If you fail to pay, if you do not pay or if you fail to pay the necessary duties, taxes, and other charges within the period or within the time provided for under the law, then your goods may be considered abandoned under Section 1129 of the CMTA. So as you can see, it is provided in the said provision, Section 1129, that even if you have duly lodged or duly filed the goods declaration, your item or your importation may still be considered abandoned if you fail to pay the assessed duties, taxes, and other charges on your importation. Okay? So again, what is the effect if you fail to pay the duties, taxes, and other charges? Your goods or your items may be considered abandoned. Okay? And what happens if your goods have been or may be considered abandoned? Then it will be subject to disposition under Section 1139 of the CMTA. Again, it is clear under Section 1139 of the CMTA, abandoned goods are subject to disposition by the Bureau of Customs. So again, going back to our previous provisions, no, sinasabi lang natin na kailangang bayaran mo lahat ng duties, taxes, and other charges due on your importation. Kung hindi mo yan mabayaran on time, malamang ay ma-consider abandoned yung iyong importation and subsequently may be subject to disposition by the Bureau of Customs. And we know how the Bureau of Customs disposes of goods in its custody. Chances are, bebenta yan, and the proceeds will be disposed of accordingly following Section 1143. So kung hindi mo binayaran yung duties, taxes, and other charges sa importation mo, malamang ma-abandon yan, and then i-dispose of yan, ibebenta yan, at yung pinagbilhan or yung pinagbentahan, yung proceeds, will go to the following. A, as you can see, A, customs duties except in the case of forfeited goods. B, taxes and other charges due to the government. And C, government storage charges. So if you notice, the first three items satisfied from the proceeds of abandoned goods are charges due to the government. Even the fourth one, expenses for appraisal, advertisement, and sale of auction goods. So this is essentially how the Bureau of Customs collects um, or generates revenues from imported goods. They collect, and if the importer fails to collect, maa-abandon yung importation, ibebenta yung importation, and yung proceeds, yun yung sasagot sa duties. And yung proceeds, yun yung magge-generate ng revenue. If and in the event that the importer fails to pay the duties, taxes, and other charges. Now, these provisions under CMTA 1132 onwards, remember that these provisions apply only in this particular instance as stated in 1132. If I may read, the civil remedies for collection of import duties, taxes, fees, or charges resulting from the conduct of a post-clearance audit shall be obtained by, okay? In other words, these provisions on civil remedies under Section 1132 onwards will apply only if there is a deficiency which was discovered after the conduct of a post-clearance audit. Because in the normal course, as we have discussed earlier, kapag ikaw hindi ka nagbayad ng duties, taxes, and other charges, pwedeng ma-abandon yung goods mo, ibebenta yung goods mo, and yung proceeds, yun yung mag-a-apply or yun yung gagamitin to satisfy duties, taxes, and other charges. But in the case of post-clearance audit, remember that in the case of post-clearance audit, na-clear na yung goods mo, na-release na yung goods mo, and they have, and again, as you may already know, audit may be conducted within a specified period for even as long as 3 years. So ibig sabihin, na-clear na yung goods mo, na-release na yung goods mo, wala nang pwedeng ibenta yung BOC because the goods have already been released. And it was only upon the conduct of a post-clearance audit that the deficiency in duties and taxes and other charges have been discovered or was discovered. So in other words, naka-release na yung goods mo, nag-audit lang, saka mayroong nalamang deficiency pala doon sa binayaran mo na duties, taxes, and other charges. So again, the scenario is the goods have been released, an audit was later on conducted, and after that audit, a deficiency in duties, taxes, and other charges has been discovered. Okay? Dito papasok or dito mag-a-apply itong Section 1132 onwards. As stated in 1132, these civil remedies for collection will apply if there are deficiencies discovered from the conduct of a post-clearance audit. Okay? So what are these remedies? Paano magkokolekta ang Bureau of Customs in the event na nagkaroon ng audit and after the audit, it was discovered that there are deficiencies in duties, taxes, and other charges. Ano yung pwedeng gawin ng Bureau of Customs? Remember, post-clearance audit means na-clear na yung goods, wala na yung goods sa customs custody. It has been long cleared and the Bureau of Customs has no longer control over it because it has been cleared and released. And it was only after audit that a deficiency has been discovered. So, since wala na yung goods, how can the Bureau of Customs still collect the deficiency? Okay? Here are the ways that the BOC can still collect that deficiency. A. Distrain and levy. And B. Civil or criminal action. Okay? A. Distraint or levy. And B. Civil or criminal action. So what is the difference between these? When we talk about distraint implies or involves seizure of property of the debtor, which in this case is the importer or the person liable to pay duties, taxes, and other charges. You seize the personal property of that importer, and that personal property will satisfy the deficiency in duties, taxes, and other charges. When you talk about levy, it's essentially the same concept. You seize the property of the importer or the debtor or the person liable to pay duties, taxes, and other charges, and such property will be held responsible or will satisfy the duties, taxes, and other charges which have been found to be deficient. Okay? The difference is distraint pertains to personal property and levy pertains to real property. Okay? What is personal property? What is real property? That is a concept discussed under your civil code. But for purposes of our discussion today, essentially, distraint and levy are the same. They are using, in other words, you seize the property of the importer or the debtor for that property to be used to satisfy the deficiency. Kumbaga yung property, kukunin mo yung property ng importer, kukunin mo yung property ng debtor, yung dapat magbayad ng duties, taxes, and other charges. Kunin mo yung property niya at yung property niya yung sasagot dun sa kakulangan na dun sa binayad niya na duties, taxes, and other charges. Okay? And B, civil or criminal action. Ibig sabihin, magsasampa ka ng asunto ng kaso, whether civil or criminal, against the liable party. The party liable to pay duties, taxes, and other charges. Okay? Can they be pursued at the same time, distraint and levy, or civil and criminal remedies? Well, the answer is here. Either or both of these remedies may be pursued at the discretion of the Bureau. So yes, the answer is yes. It's at the discretion of the BOC, but there is just one limitation. The remedy of distraint and levy is not allowed when the amount of duties and taxes involved is not more than 10,000 pesos. Okay? So kung if after post-clearance audit, nagkaroon ng na-discover yung deficiency, but the deficiency is not more than 10,000, halimbawa 10,000 flat, 10,000 lang, then you cannot use the remedy of distraint and levy. Because distraint and levy, they are not allowed when the deficiency or the duties and taxes involved is not more than 10,000 pesos. Okay, that's the only limitation. But essentially, which remedy to use, kung sabay ba siya o magkasunod ba siyang gagamitin ng BUC, is upon the discretion of the Bureau of Customs also. Okay? Sino naman yung gagastos? Of course, when you do or when you resort to distraint or levy or when you file a civil or criminal action, may gastos na kasama yan. Okay? There are expenses involved and the law says that the BOC shall advance the amounts needed to defray costs of collection by means of civil or criminal action. Okay? So ang magagastos dyan, essentially, is the BOC. It will advance. It will advance the expenses for it to be able to resort to these remedies. Okay? If you look at these provisions of your CMTA, these are adequately implemented or these were also reproduced or echoed by the provisions of your CAO 1-2019, specifically on post-clearance audit. As we have discussed earlier, ito naman kasing civil remedies na ito nangyayari lang or pwede lang gamitin if there were deficiencies discovered after post-clearance audit. Okay, so if you check your CAO 1-2019, you will see essentially the same provisions under that particular CAO. Okay? So earlier, we mentioned or we discussed the concept of distraint and levy and civil or criminal action. Okay? But under Section 1133, this provision introduces a new concept. It's the concept of constructive distraint. Okay? Constructive distraint. In other words, uh, a scenario may arise wherein a civil or a criminal case has already been filed under the previous provision. And while the case is pending, there is a danger that the property of the importer or the debtor will be dissipated or will be removed or will be hidden. In other words, halimbawa kung magsampa ng kaso, whether civil or criminal, ang Bureau of Customs, chances are the person liable for duties and taxes, itatago niya na yung property niya or ililipat niya na yung mga property niya para hindi ma-distrain or ma-levy. In other words, the importer, chances are, will avoid execution. Kaya itatago niya na yung properties niya so the importer can avoid distraint or levy. Now, to avoid that scenario, the law gives the government or the Bureau of Customs the remedy of constructive distraint. Okay? If you read this provision, the purpose is clearly to safeguard the interest of the government. So ano tong constructive distraint na to? This is different from distraint that we discussed a while ago. This is just merely constructive distraint. Okay? Para lang maiwasan yung scenario na while the case is ongoing, itatago or i-remove or itatransfer unlawfully yung property na tinatarget sana ng gobyerno. Okay? When is the remedy of constructive distraint available? It's here in 1133. If there is a property of a delinquent importer who, in the opinion of the commissioner, 1. Is retiring from any business subject to duty and tax, 2. Is intending to leave the Philippines, 3. Or is intending to remove the property from the Philippines, number 4. The importer is intending to hide or conceal the property, or number 5, the importer is performing any act tending to obstruct the proceedings for collection. Okay? So in other words, if there is any conduct of the importer which will tend to impede or obstruct collection proceedings, the BOC may resort to or may avail of the remedy of constructive distraint. Kumbaga, this takes the nature of a preliminary remedy. Hindi pa ito yung remedy mismo. This is just preliminary. Just to avoid the scenario wherein all the properties will be gone by the time that the case has been concluded. Okay? Paano ginagawa ang constructive distraint? It is effected by requiring the importer or person in possession or control of such property to sign a receipt. Okay? And to obligate that person to preserve the distrained property on the state and condition at the time of the government seizure and not to dispose of the same in any manner whatsoever without express authority of the commissioner. So in other words, if there is constructive distraint, in effect, inuutusan ng gobyerno kung sino man yung may-ari nun o kung sino man yung may possession o control dun sa gamit na yon, huwag mong gagalawin yan. Huwag mong ibebenta yan. Huwag mong itatransfer yan. Okay? Ingatan mo lang yan. Preserve it in the state and condition as it is now. And hindi mo siya pwedeng ilipat, hindi mo siya pwedeng i-dispose of unless there is express authority from the commissioner. Okay? Bawal mo siyang ibenta. Bawal mo siyang sirain. Okay? Preserve it. Do not transfer it. Okay? Do not dispose of it unless you have express authority as mentioned in this provision. Okay. If the importer or person in possession and control refuses or fails to sign the receipt, then the customs officer effecting the constructive distraint shall prepare the list of property and in the presence of two witnesses, leave a copy thereof in the premises where the property distraint is located, after which the property shall be deemed to have been placed under constructive distraint. Again, earlier we said, pipirma ng receipt si importer or person in possession. Kung ayaw niyo pumirma, meron ding remedy rito. Okay? Kailangan lang may witnesses and then pwede nang iwan yung listahan and the property is deemed constructively distrained. Okay? So let's continue. We have discussed the concept of constructive distraint. Let's go back to the concept of distraint. In more detail, paano ba ginagawa yung distrain o pag-distrain ng property ng importer o ng isang tao na may utang sa BOC? Okay? Upon failure of the person owing any delinquent duty, tax, and other charges to pay at the time required, the commissioner shall seize and distrain the goods, chattels, or effects and the personal property. Okay, let's stop there in the meantime. An important thing to consider here is that there should be failure on the part of the person owing the delinquent duty, tax, and other charges to pay. In other words, the person, kung sino man yung may utang o kung sino man yung may delinquent duties, taxes, and other charges, he or she or it should be given the opportunity to pay and there was failure on his or her or its part to pay. Again, give them the opportunity muna na magbayad. Baka naman babayaran naman kaagad. Okay? Give them the opportunity to pay and after failure to pay, then that's the time that you can resort to this remedy of distraint. Okay? Remember also that when you do or when you resort to distraint, as you can see from the last part of this provision, it should only be insufficient quantity to satisfy the duty, tax, or other charge and the expenses of the distraint and the cost of the subsequent sale. In other words, you do not distrain properties of the importer more than what is necessary to cover the delinquency in duties and taxes and to cover the expenses of the distraint and subsequent sale. In other words, kung ang utang lang naman na duties, taxes, and other charges ay 20,000 and then the corresponding expenses ay 10,000 lang naman, then you only distrain property to such extent or to cover only such amount. You don't distrain all of the property of the importer or the debtor. You just distrain such property as may be necessary or as may be sufficient to cover what needs to be paid under this provision. Okay? Physically, how is distraint effected? Okay, the officer serving the warrant. So there is a warrant there. It's called the warrant of distraint. Okay? The officer serving the warrant shall make or cause to be made an account of the goods, etc., the properties, an account of the property. So there is an account of the property which should be signed by the officer and left either with the owner or person from whose possession such properties were taken. Okay? Or at the dwelling house of such person with someone of suitable age and discretion. Okay? An important thing to note dito sa warrant of distraint na to, aside from the list of the properties being distrained, there should also be a statement of the sum demanded and the note of the time and place of sale. Okay? So dapat doon sa warrant, magkano ba yung utang? At kailan at saan ibibenta yung property if ever. Okay? The purpose, again, going back, the purpose, of course, the opportunity for the importer to pay yung delinquencies niya. Okay? And satisfy his expenses. When you talk about distraint, again, we mentioned that distraint talks about personal property. And one particular personal property here is stocks or shares of stock. Okay, when you talk about stocks or shares of stock, you are talking about a personal property which signifies a portion or ownership of a portion of a corporation. So let's say, for example, you own shares of stock or you own stocks of Jollibee Foods Corporation. You are part owner of the said corporation as may be evidenced or as may be shown by your stock ownership. Okay, so when you say stocks, when you say shares of stock, you are talking about a portion ownership of a portion of a certain corporation. Okay, so that is considered personal property. That personal property may be liable to distrain. So kung halimbawa, yung may utang ay mayroong shares of stock of a certain corporation, the BOC may go after that certain stocks or shares of stock to satisfy the debt of such person. Okay? So kung ako may utang ako sa BOC, may duties and taxes akong dapat bayaran and I did not pay, I refused to pay, and if I own certain shares of stock, the BOC can go after such shares of stock to satisfy kung ano man yung pagkakautang ko sa BOC. Okay? In such case, how is the warrant of distraint served? It's here in the CMTA. The stocks or other securities shall be distrained by serving a copy of the warrant of distraint upon the importer and upon the president, manager, treasurer, or other responsible officer of the corporation, company, or association which issued the said stocks or securities. Again, going back to my example earlier, if ako may utang ako sa BOC and I failed and refused to pay, and if I own shares of stock of Jollibee Foods Corporation, the BOC can go after my shares sa Jollibee and will serve a warrant of distraint sa akin bilang importer and sa officer or responsible officers ng Jollibee Foods Corporation which issued the shares of stock that I own. Okay? So in other words, yung pagmamayari ko dun sa korporasyon na yun, the BOC can go after such shares of stock. Okay. Debts or credits. Ano yung ibig sabihin nito? You can say that this is tantamount to receivables. By receivables, halimbawa, ako yung importer and there is another person, let's say person X, which owes a certain amount to me. In other words, I have credits, I have debts and credits of another person under my name. Okay? Ako may utang sa BOC and another person, person X, siya naman yung may utang sa akin. So that's the scenario being envisioned under this paragraph. Okay? In that scenario, the BOC will go after what person X owes me. In other words, imbes na si person X magbayad ng utang niya sa akin, ididiretso na niya sa BOC na siya magbabayad. That's what the BOC will go after. Okay? Debts and credits. Debts and credits shall be distrained by living with the person owing the debts or having in his or her possession or under his or her control such credits or with his or her agent a copy of the warrant of distraint. Okay? So in other words, in that scenario, ako may utang sa BOC, si Mr. X may utang sa akin, the BOC will leave with Mr. X the warrant of distraint. So in other words, if you will read the next sentence, the warrant of distraint shall be sufficient authority for the person owing the debts. In other words, in our example, si Mr. X, to pay to the commissioner the amount of such debts or credits. So in other words, as I was saying earlier, si Mr. X, imbis na bayaran niya yung utang niya sa akin, diretso na siya na sa BOC magbabayad para yung utang ko sa BOC masatisfy o mabayaran. Okay? That's simply how this goes. So ibig sabihin pati pagkakautang ng ibang tao sa'yo puwedeng habulin ng BOC. Bank accounts. So if ako, may utang ako sa BOC in the form of duties, taxes, and other charges, and I happen to have bank accounts also, then the Bureau of Customs can go after my bank accounts. Okay? Paano naman gagawin yon ng BOC? Bank account shall be garnished. So ito take note of the word garnishment. So when you distrain a bank account, the more specific term or the more particular term is garnish or garnishment. Okay? Bank accounts are garnished by serving a warrant of garnishment upon the importer, me, in our example, ako yung may utang, and upon the president, manager, treasurer, or responsible officer of the bank. So ako, tsaka yung officer ng bangko, parehong makakatanggap ng kopya ng warrant of garnishment. Ibig sabihin, basahin niyo yung next sentence. If you will read the next sentence, upon receipt of the warrant, the bank shall turn over to the commissioner so much of the bank account as may be sufficient to satisfy the claim of the government. So kung magkano yung utang ko, kukunin ng bangko from my account at ipambabayad sa BOC. In other words, it will be just as simple as the bank account will get money from my account and pay my debt to the BOC. Again, in that case, nasatisfy, okay, nakakolekta yung BOC from my bank account. Okay, after distraint, there should be a report on the distraint, okay? The particulars or the details are flashed on your screen. It should be within 10 days from the receipt of the warrant. It should be submitted by the Commissioner to the Secretary of Finance, provided that the Commissioner shall have the power to lift an order of distraint subject to rules and regulations promulgated under this Act. So pwede rin i-lift yung warrant of distraint or yung warrant of garnishment. You just have to ask that such warrant be lifted. If for example, meron kang bank account, sinerva ng warrant of garnishment yung bangko mo, then you can move. Don't touch my bank accounts anymore. I'm willing to pay. Babayaran ko na. Huwag niyo nang galawin yung bank account ko. Halimbawa, yung shares of stock kanina. The BOC wants to get your shares of stock para mabayaran yung utang mo. You can say, no, don't touch my shares of stock. I will pay whatever I owe the Bureau of Customs. Please lift the warrant of distraint or the warrant of garnishment. So again, the point here is you can ask that the warrant be lifted, that the order be lifted. Again, subject to payment. Kasi hindi naman ililift yan unless and until you pay or signify or secure your intention to pay. After all, again, the bottom line is how will the BOC collect? Okay? Levy on real property. As I was saying earlier, levy is essentially the same as distraint. It's just that levy is the counterpart for real property. Okay? Real property. Among others, yung mga lupa and properties erected thereon. Okay? How are they levied? How are these real properties levied? After the expiration of the period within which to pay the duty, tax, and other charges as prescribed in this section, real property may be levied upon. Okay? Again, it is important before levy may be resorted to, there should be first an opportunity to pay. Okay? Bigyan mo muna ng chance si importer na isatisfy or bayaran yung duties, taxes, and other charges niya. Okay? And as we have also mentioned earlier, this remedy of levy may be resorted to simultaneously or prior to distraint of personal property. Pwedeng sabay, pwedeng mauna yung distraint, pwedeng mauna yung levy. Okay? Paano ginagawa ito? The commissioner or the duly authorized representative shall prepare a duly authenticated certificate showing the name of the importer and the amounts of duty and tax and penalty due. The certificate shall operate with the force of legal execution throughout the Philippines. So if you have real property, kung may lupa ka man, saan man dito sa loob ng Pilipinas, pwede siyang masubject to levy. Pwedeng ma-levy yan. Okay? The levy shall be effected by writing upon the certificate a description of the property on which levy is made. Okay? At the same time, written notice of the levy shall be mailed to or served upon the Register of Deeds of the province or city where the property is located. And also, the notice of levy shall be served upon the importer. Okay? When you talk about Register of Deeds, this Register of Deeds, this is the sabihin na natin government official or government office which has custody of all the covering titles within such city or municipality. If you want to check the veracity or the authenticity of a title covering a certain real property, halimbawa titulo sa lupa, whether it be an OCT or a TCT, you can verify it with the Register of Deeds. The Register of Deeds is supposed to be the repository or the custodian of such titles and records within such city or municipality. So, if the BOC intends to go after your real property, kung hahabulin ng BOC yung lupa mo, the BOC has to notify or serve a notice of levy to the Register of Deeds. Okay? Because it is the Register of Deeds which has custody over the titles covering your real property. Okay? In case the warrant of levy on real property is not issued before or simultaneously with the warrant of distraint on personal property, and the personal property turns out to be insufficient, then the commissioner or his representative shall, within 30 days after execution of the distraint, proceed with the levy on real property of the importer. Okay? So kung nag-distrain ka muna and kulang yung personal property ng importer, then after such distraint, kung kulang pa rin, pwede ka mag-proceed na mag-levy ng real property. Okay? Again, similar to distraint, meron ding report. What happened to the warrant of levy? There should be a report as mandated under the CMTA. Okay? We mentioned also earlier that aside from distraint and levy, the BOC, in order to collect duties, taxes, and other charges, fines, and penalties, may also resort to criminal and civil proceedings. Sino yung magsusupervise or may control over such cases or proceedings? Civil and criminal actions and proceedings instituted on behalf of the government under the authority of the CMTA shall be brought in the name of the government of the Philippines and shall be prosecuted and handled by the BOC with the assistance of the DOJ. So again, kung magsasampa ng kaso ang gobyerno to collect duties, taxes, and other charges, whether via civil or criminal action, it should be handled by the BOC with the assistance of the DOJ. Okay? Take note of the last phrase also in this provision, provided that no civil or criminal action for the recovery of duties or for the enforcement of any fine, penalty, or forfeiture shall be filed in court without approval of the commissioner. Okay? So the approval of the commissioner is also important before the necessary civil or criminal case can be filed in court. Okay, so that's all for today's discussion. I hope you were able to learn or you were able to gain more insights on how the government is able to collect duties, taxes, and other charges in cases that a deficiency is discovered upon post-clearance audit. So that's it. Good night. And I hope you learned something from today's session. Thank you, everyone.